Auzubillahiminash-shaytanir-rajim. Bismillahir-rahmanir-rahim. My name is Ali Shahzeb, and today my presentation topic is why arbitration is preferred over judicial settlement. First of all, I will discuss about introduction. Arbitration, along with judicial court settlement, is one of the two ways to resolve disputes satisfactorily. And also, there are some similarities and differences between these two methods. If we talk about similarities in between these two methods, or uh, that is, both are dispute resolving methods. And also parties use arbitral tribunal and judicial tribunal due to their binding decisions, rather than using diplomatic modes like mediation and conciliations. And also there are some distinction between them in the term of procedure and the law which is applied to the dispute. In arbitration, there is a flexibility in procedural and applied law. That's why parties preferred arbitration over judiciary for settlement of disputes. The term of procedure, arbitration is divided into two categories, ad hoc arbitration and institutional arbitration. In ad hoc arbitrations, parties choose their own procedure and applied law for the resolution of disputes. Arbitrators in ad hoc arbitration are bound to follow the law that is agreed upon by the parties. And in institutional arbitration, parties are bound to follow the law of chosen institution, like ICSID and Permanent Court of Arbitration. Now I will talk about basic principle on which we prefer arbitration over judicial settlement. First one is binding outcome, and second one is party autonomy and also expertise. Due to these principles, we can prefer arbitration over judicial settlement. First of all, I will discuss about binding outcome. In arbitration, arbitrators give decisions in the terms of award that is binding on parties. Article 34, paragraph number 2 of Unilateral Arbitration Rules says, all awards shall be made in writing and shall be final and binding on the parties. The parties shall carry out all awards without delay. This binding principle reflected from the party consent for chosen arbitrator and agreement that his decision would be binding on parties. Next principle is party autonomy. The major principle which gives preference to arbitration over judicial settlement is party autonomy. In contrast to judicial settlement, in which fixed rules are followed, but in arbitration, parties choose own procedure and applied law for resolving disputes. And also in judicial tribunal, there are elected judges to try disputes, but in arbitration, neutral or body of neutrals are chosen by parties themselves. For this purpose, I will look at Unilateral Arbitration Rules 2010 amended in 2013. Article 1, subsection 1 of Unilateral Arbitration Rules says, where parties have agreed that disputes between them in respect of defined legal relationship, whether contractual or not, shall be referred to arbitration under the Unilateral Arbitration Rules. Then such disputes shall be settled in accordance with these rules, subject to such modification as the parties may agree. And also, Article 21, subsection 1 says the arbitral tribunal shall apply the rules of law designed by the parties as applicable to the substance of the dispute. Also, Article 19 of Unilateral Arbitration Rules shows party autonomy in the procedure of arbitration. This article says, subject to an agreement by the parties, the arbitral tribunal shall promptly after its appointment determine the language or languages to be used in the proceedings. All these articles that are discussed in the above show parties' autonomy in the procedure of arbitration and shows how parties participate in the whole procedure of arbitration. Finally, I will discuss about expertise. Arbitration is better than judicial settlement because in arbitration disputes are resolved by the expert arbitrators who have knowledge about particular field. For this purpose, I will look at Article 8, subsection 1 of Unilateral Rules 2013. This article says if the parties have agreed on a procedure of appointing the arbitrator or arbitrators, that procedure shall be followed. Parties can design a process to select arbitrator with specific technical, legal, or industry expertise. For example, engineering, maritime law, and finance. That's why arbitration is preferred over judicial settlement due to its expert decisions. In arbitration, expert arbitrator give award. Finally, I will conclude my topic that arbitration is increasingly preferred over judicial settlement due to its efficiency, cost effectiveness, privacy, expertise, and global enforceability. Arbitration offers a more practical and business-friendly method of resolving disputes, particularly in commercial and international contexts.